on the show with us. But
Good
thank you
morning,
for joining
gentlemen.
us.
Good morning, Mr. Alexander. Thank you for joining us this morning.
Good morning. Yeah.
Can you give us, as we start, an update on the impasse between Posinco and the MovieTowne management, please?
As it stands, because of a breach of a lease that existed between the Port Authority and TCDC, the port was forced to re-enter the property. And since then, the TCDC understandably has gone to court with an injunction against the port, and we are awaiting the determination of the court at the moment.
When you said re-enter, what do you mean? Subsequent to the July 1st entry into the complex?
I'm sorry, let me hear that question again.
You said you were forced to re-enter the compound. What does that mean? Yes. Subsequent to the first entry in July?
No. I'm trying to use the legal terms here as I understand them. And if a tenant breaches a lease, the landlord has a right to re-enter the property. In other words, to evict them.
Okay, so it was your intention to go into evict? That was the intention at that point?
I'm sorry?
It was your intention to evict at that point?
When the action was taken to re-enter the property, as I said, that's a term that I understand that is used legally, and that's by right because the tenant did not honor the terms of the lease. In this particular case, they did not pay the rent that was expected, and as such, the landlord then re-entered the property. In other words, went into the space and possessed the space. And took
Mr. Alexander, we spoke to Mr. Chin yesterday, representing TCDC, and he was saying that in his opinion, and let me preface it by saying that as far as MovieTowne saw it, the Port of Spain Port, the Port Authority, was in breach of the current order of the court by not allowing them unrestricted access to certain parts of the MovieTowne infrastructure, specifically, of course, their offices and stuff like that. And they were restricting them between 8 to 4 at this point, and there was a certain amount of bullying in terms of how the Port Authority was handling the matter. How do you respond to that?
Well, that is not the understanding of the port. The re-entry into the property means that the landlord now has possession of the property. We cannot re-enter the property and then simply walk out and allow them to function as normal. If a re-entry takes place, it means that your operations are affected in some way. No. So having taken over those 2 locations on the property, we have to occupy that space because we took the action to re-enter.
But he's saying that the court order says that you all are not supposed to interfere, and that you all are in fact interfering by not allowing them access to the administrative offices, and that there's no court order that says that. So do you consider yourself in breach of that court order?
No, we are not. No, we are not. If you re-enter the property, you would have disrupted the operations, the current operations as they were, right? That is, I mean, understandable as far as I'm concerned. But the thing is, when we are there, having been or now being in possession or on site, there are discussions that can take place to permit you to get certain access to reasonable access to certain parts of the property, because we deliberately have no intention and do not intend to disrupt the operations at MovieTowne. All the tenants are still in place. All of the public can go in and out and continue business as usual.
I understand your point of re-entry on the basis of whatever the lease agreement is, but I'm talking specifically to the court order that was granted. Yesterday, he's saying specifically that the Port Authority was in breach of the court order. I'm not talking about your right of re-entry as a landlord, which you're claiming, which initiated the entire sequence of events. I'm talking about post it going to court. There is an interim court order, and I think the matter goes back to court sometime this week before a different judge. He is saying that the substance of that court order, that interim court order, is being breached by the Port Authority. I'm not talking about your right of re-entry as a landlord, which you keep coming back to. I'm talking about the court order itself. Or are you not familiar with the terms of the court order?
The Port Authority does not agree with that position of Mr. Chin.
Does Mr. Alexander, Mr. Chin indicated that there are personnel from the Port Authority in the offices itself of TDCD. Is that correct?
There are security officers on site. So it's two specific areas related to two specific areas of MovieTowne.
Could you share those areas with us and the reason for those security officers being there?
Well, that's part of the re-entry process. The two areas were the administrative offices and secondly, the banquet spaces, because those are the two offices that were identified as related to TCDC in accordance with the terms of the lease. So the re-entry means that you occupy spaces related to the tenant. We couldn't go anywhere else. We can't lock down the entire place deal with a matter specifically related to TCDC. So those are the two areas that were identified that based on our advice, excuse me, that we were able to re-enter.
You used the term lockdown, and earlier on in the conversation, you said that you do not believe that you're impeding the business operations as per the court order. How can you use the term lockdown without having some sort of impact on the business operations of TCDC?
Well, Paul, again, I'm saying that if the law enables a landlord to re-enter a property of a tenant because of a breach in the of the agreement, that speaks to a disruption of the operation. So that's an initial position. Now, if you at the time is taken and that the plan is made to re-enter the premises, then it is not reasonable to expect that he will simply enter the property and then leave. So if the court had decided to rule that the PATT had done so illegally, or if they think that based on after determination that the PATT should move out, then we move out. But we cannot have a presence and that not have some kind of effect on the operations.
So what you're saying, and correct me if I'm wrong, so the presence of the security vis-a-vis the re-entry is to maintain the interest of Posinco.
Correct.
All right, let's go back a bit. Mr. Chin also told us yesterday in the interview that there is a 5-year cycle of renegotiation of the terms and conditions of the lease. Would that be correct?
The lease permits or calls for the lease is a 5-year term. After which you can have a further extension of 5 years after a particular process is gone through.
And that process would entail, I guess, reevaluating the terms and conditions of that lease agreement as it stands at that point. Would that be correct?
That is correct.
Mr. Chin indicated, yes, and I'm paraphrasing here, that the Posinco attempted to include the infrastructure invested by TDCD in the assessment process, and he thought, and I'm paraphrasing here, that was unfair because Posenco did not make that investment in the infrastructure, and so that should not be included in the assessment process. Is that an accurate depiction of what's happening presently, or do you have a different version?
No, it is not. Because the valuation, let's talk about the valuation process. According to the lease, the valuation process goes like this. Both parties agree that, look, okay, we're coming up to a new lease period and we need to negotiate on the cost of the price of the lease, which again is also permitted by the agreement in terms of how you go about doing that. No, how does that happen? Both parties agree on a valuator. Both parties sign on that this valuator is going to do the valuation. Both parties share the cost of that valuator to do that valuation. Both parties also agree to accept the terms or the findings or the report from the valuator. In this particular case, the valuator decided what the cost was. Both parties and TCDC began to pay that lease. They paid the lease that was agreed based on the valuation. So, sometime after, and this was after COVID that was the period. Because during COVID, by the way, the PATT gave significant concessions to all our tenants, all. When the country was locked down for COVID, the PATT charged or received no rent for a period of time from tenants. It may be interesting to find out whether or not TCDC also treated its tenants the same way. So that took place for a while.
When did that happen? When did that arrangement, that suspension of the lease rental come to an end post-COVID?
Post-COVID, in 1 second, November of 21, I think, from April to November, there was various degrees of concession. When we were locked down completely, there was zero rent. Then we kind of prorated it thereafter when the country started opening and businesses started getting back into business, getting back into business.
Is that the point at which TCDC found that the arrangement should have been reviewed?
I'm sorry?
Is that the point at which, because you're saying there was a prorated approach to resuming the level of rental that would have been agreed to before COVID? Would that be correct?
Correct, yes. And for TCDC, that period ran until March 22. That consideration went until March 22. There was a series of concessions in there for rent. But
so at what point did TCDC indicate that they were uncomfortable or in disagreement with the rental arrangement?
Just before, and don't hold me to this date in terms of time, but chronologically I'm trying to put it, let me just say this. While all these concessions were going on, that was still within the period of the lease, right? That should have been in place. So it means that, and during that time, the lease would have that particular lease would have been up for renewal. So we had to then start getting the new lease period taken care of. And therein, in that period, TCDC all of a sudden found out that the rent that they had paid when the valuation was determined was paid in error. Now, I I will leave that as it is.
I don't understand that. What?
Well,
How
well,
can man be paid in error? I don't understand. Explain
if
that.
if I may interrupt, Paul, sorry, Mr. Alexander, I don't know if you're connecting what you just said there to when Mr. Chen told us that one of the fundamental arguments that TCDC has with the evaluation was that they were including the buildings, which Paul referenced, and that the evaluation should simply have been for the occupation of the land. And so he indicated that there was rethinking, let me put it that way, my words, rethinking of TCDC paying that rental because they felt it was wrong to have included the buildings as part of the evaluation process.
Okay, so and my response to that was not Posinco's doing. That was as a result of an evaluator that was selected by both parties. Posinco didn't decide that. And also in the lease and the report of the evaluator, the report stated specifically the terms of the lease of the report that was done in the report. Sorry, they spoke specifically that the conditions under which the valuation was arrived at. All right. So Posinco doesn't get into making those decisions. Posinco will be guided by whatever the reported valuation is. Right.
So Posinco's position is that there was an agreement for a evaluator between Posinco and TDCD. The evaluator came up with a valuation. This is before COVID, and the MovieTowne was paying that. So that is the position that Posinco maintains in terms of what is the present evaluation. Now, you indicated that this cycle, the evaluation cycle, is come up again now. Is that it?
Oh yeah, we're currently in another cycle at from the year 2021 to 2026.
Has an evaluator been agreed to between both parties?
No, it has not. The most recent issue where that is concerned is that TCDC selected the evaluator. The PATT agreed to the evaluator selected by TCDC.
Mm-hmm.
TCDC is yet to put in writing or to confirm that in writing in our agreement so that the evaluator can be engaged. So,
Mr. Chin also said one of the problems in this situation is that Posinco / the port is very tardy in responding to correspondences. How do you respond to that, making this negotiation quite protracted?
Based on the information that I have and I have seen and been a party to in terms of being involved in, I cannot agree with Mr. Chin's position. I cannot.
At what point did Posinco believe that this situation deteriorated so badly that it warranted re-entry of the property as you described it earlier?
Let me go back to this point. When as in any lease, and actually, having issues with the values and prices is not an unusual activity in terms of lease agreements. If and the lease usually, and in this case, speaks to if there's any disagreement with the value, the cost that is to be determined. If there is any disagreement, the expectation is that the tenant will continue to pay what they were paying prior to this issue rearing its head until that issue is resolved.
Which is what they would have agreed to before.
Correct.
Right.
That is in the agreement.
Mm-hmm.
TCDC chose not to pay. Understand this. TCDC chose not to pay from 2021, April 2021.
Is this until July this year when the Posinco decided to take the action of re-entry?
To date.
And that is the period within which the $10 million in arrears that was published in the newspaper was accrued?
Total. That's the total for that period. Yes. No. Let me just back up. When they did not pay any rent at all, they took zero. At that stage of the game, we wrote with and they determined to advise that we will be, we more than likely will have to go to court on this matter. I would also state that I called Mr. Chin on the phone to have a without prejudice conversation, notwithstanding the fact that we had written them a letter. So I thought I'd explain to him where we were, why we were where we are, and whether we could work this thing out. Mr. Chin told me, he said, Mr. Alexander, we could pay the rent, So I said, well, why aren't you paying the rent? And he said to me, he was advised by his lawyers not to. I subsequently understood what the advice was as a result that they thought this valuation was flawed. But that is what Mr. Chin told me. He said, we can pay the rent. And by this time, I mean the old rent, whatever that figure is. So our action against Mr. Chin at the moment is for not paying any rent at all. It's not about a new rate here. It's about whatever the old rent was. The law requires you to continue paying that until you resolve the issues, which we understand. We're not. It's not the best position from our perspective, but we appreciate that the law permits it. Mr. Chin and the TCDC chose, on their own volition, not to pay the PATT any rent. That was unacceptable.
So now $3 million had been paid by the 28th of August. Would that be correct?
Some money was ordered. Well, I shouldn't say ordered. A decision was made in the court that they would pay $3 million to the court.
What does that enable? How does that impact the situation?
That's a legal part of the situation. That has no impact on us at the moment. That's part of the legal proceedings.
Right.
In other words, that money was not paid to PATT.
Is the and this is going back just from my understanding, does the agreement contemplate a per square footage cost for the lease of the compound?
There's some model that is, but in short, yes. I mean, the lease is based on the land that the port is leasing, and the land is measured in acreage.
Right. So what's next moving forward? What do you expect? Because now, as Richard said earlier, and Mr. Chin told us, and I think you confirmed that the matter goes back to a new judge later this week. What is Posenko hoping to come out of that situation?
Well, we await the determination of the court. We think we have a good case before the court, and we await the determination of the court.
And I guess the immediate issue is the arrears, minus the $3 million. Would that be correct? Is there any interest to be applied to that?
My understanding is the court will determine that.
Or if there's an interest to be applied. And then what now, given I'll use the word stalemate, of a new assessment and the agreement on a new evaluator for the situation moving forward?
Well, if at the moment, based on the re-entry law as we understand it, means that when a property is re-entered into, the lease is terminated. It means that the lease is terminated, right? Based on the outcome of so at the moment, there's no lease that exists between TCDC and the PATT.
So a new lease has to be agreed to, and terms and conditions of a new lease now has to be agreed to.
Correct.
Now, I'm presuming no one wins if there's an eviction. The port doesn't win. The huge investment TDCD made doesn't win. The public doesn't win. So in the interest of all concerned, some sort of agreement has to be made for this going concern to continue. Would that not be so?
I think that's a reasonable position to adopt, yes.
Do you think, given the fact that it's now in court in a particular realm to deal with the arrears, and this court matter is to deal with the arrears, correct?
Yes. Mm-hmm.
That the parties can sit down and come to some sort of agreement on an evaluator for the next cycle, or I guess the present cycle, given what you've said, because that cycle ended, and some arrangement moving forward.
Well, he's not saying that there's a cycle. He's saying that the lease is now terminated, that it's a
a new lease.
Completely, yes.
Right. And the thing is that the PATT has already agreed to a named valuator, all that suggested by TCDC. So all that is required now is for TCDC to respond to the letter sent to them by PATT regarding that valuation. So
there are two matters here: one, the arrears, and two, the new assessment based on the agreed to evaluator as suggested by TCDC.
Yeah, well, hold on. Let's not combine both of these things, right?
I separated them.
Yeah. Any discussion on the lease going forward, or on a lease going forward, will be determined and guided by whatever the court rules.
Yeah.
On the matter, before the court. So thereafter, any other issues can be dealt with. But to answer your question, your question earlier as well, the opportunity to negotiate, to discuss, is always available. Even courts from time to time advise and suggest that people try to negotiate and discuss issues before it being determined in the court. So that doesn't go away.
Yeah. Well, I mean, hopefully it gets to that point that there could be some level of amicability in terms of how this matter is settled. Because as Paul would have indicated, and as you would have concurred, nobody wins if it becomes more and more hostile. And not only is a substantial investment up in the air, but the amount of jobs that is facilitated by the existence of the entity. So I mean, hopefully that will eventually come to pass. That some sort of settlement will come to pass.
Let me state specifically at this stage, categorically, that there's no hostility from the side of the PATT and POSINCO. Absolutely none. We are dealing here with a strictly legal position, and that is what is being determined in the courts. We have never not agreed to have discussions on this matter, and our intent during the re-entry, one of our key concerns was ensuring that the tenants and the public will not be unreasonably affected and impacted by this re-entry process. And I think so far that we have been able to validate that.
Would you be able to confirm? I read in one newspaper, and I'm subject to your correction if it's inaccurate, that the monthly rental is $194,000.
Well, depending on the rate that you're using, it is a figure that can come up from time to time. And by that I mean I don't want to say specifically, but it can be a figure that was arrived at a particular point when certain concessions may have been considered and so on.
And is it that, and I think one of the points Mr. Chin raised is that he was given certain concessions under the Tourism Act when he entered into the agreement at the start 21 years ago. How has that impacted negotiations through the years?
Paul, I'm in no position to speak about that, because that is the first time I heard that is when Mr. Chin said it on the radio. I don't know anything at all about that.
So that never came up. It came to your attention before and has not been part of the...
Well, Paul, if I may intervene, I think he meant that with regard to inland revenue. I don't know.
It's inland revenue. I stand corrected. Sorry. Okay.
I don't think he meant that with regard to
this is not the rental thing. This is BIR.
Yeah.
Okay. All right, Mr. Alexander, is there anything you would like to add in closing that we may have omitted?
One thing I would like to say is that the PATT really regrets that we have arrived at this position after the failure to meet a acceptable agreement as this thing progressed, and that we have every intention to honor our commitment to the tenants of MovieTowne and the public as a whole to ensure that business as usual, as usual can be under the circumstances, will continue at MovieTowne.
Well, as you say that, something has occurred to me. Is it that you were asking for the tenants at one point to pay the rent to you directly to PATT?
Well, our understanding of a re-entry is that once the re-entry is made, you will now become the landlord of the facility. If you are the landlord of the facility, then the rent is supposed to be paid to you.
But the legal advice that we have received, it could be inaccurate, is that they have no agreement with you. The tenants, that is.
Well, correct. That is correct. However, the re-entry process terminates the existing lease. So the tenants have to be tenanted to somebody.
But would you have agreements with those tenants now to establish a particular rent?
No, but didn't the court order address that issue?
I was just curious as to why Pat requested that the rents be paid to them, but Mr. Alexander has cleared it up in his opinion.
It's not a question of Pat wanted that to happen. That is what the law permits. Because don't forget, if you re-enter, the existing lease no longer exists. So somebody has to pay
so you become the de facto lessee.
You become the de facto landlord.
Yeah.
Yes.
Okay. All right. Thanks again for being with us this morning. We appreciate your time and your contribution. I'm sure somebody will call and ask for this tape this morning.
It goes with the territory, unfortunately.
It goes with the territory. We have it recorded. So thank you so much. We appreciate your time, and we hope to get an update as time progresses. As we said earlier on, we hope this reaches some sort of resolution because it's a significant investment. It has added value to Trinidad Tobago's landscape, both for MovieTowne stakeholders and the Port Authority and the general public in Trinidad Tobago. So it's in the interest of all concerned for some resolution to be reached.
We too share that position.
Thank you so much.
All right. Thank you, Mr. Lyle Alexander, for being with us.
Have a good day, gentlemen.
You too. All the best to you. Yeah. All right. Of course, he's the chairman of the Port Authority.
I don't know of any re-entry on the basis of a claimed breach of a lease agreement that does not in some way become hostile.
Well, if you go with police and say we lock it, he used the word lockdown there. Here is that, not my words, his. At some point, hostilities will arise.
At some point.
I ain't gonna say, okay, I lock in my gate and you're putting guards in office.
It becomes hostile because human emotions get involved.
Human emotions, and I'm going to be upset. Wow, never a dull moment.
No. Obviously, the court will have to be the arbitrator in this case in how this eventually gets resolved, or at least guides towards a result. Because he is right. God sometimes just say, can't you all work this out?
Well, that's the ideal situation, that they go back to the negotiating table and they come to some sort of agreement. There are two issues here, as he identified. One is the issue of the arrears. I don't know how the $3 million that's already been paid as of August 28th or 27th would factor into that. Mr. Alexander, didn't identify whether there was interest to be applied. The court will determine that or not. And also the issue of the new agreement, because there's no agreement there's no agreement now.
He said one would have cropped up from 2021.
Yeah,
that's when the new one would have, which is kind of in the middle of COVID. So I was a little confused because he said that there were some concessions given for COVID. And so when did those actual concessions cease? When did you as an agency decide COVID is now done?
And we're going to restore full.
And we could restore full. What is that point? What is that date point? I don't know. It can't be 2021 because 2021 it was still locked. There was a certain it was still locked.
When did we end the lockdown? Is it just before the school term in 22 or end of 21?
I think it was supposed to be the end of 21, if my memory serves me correctly. But
and then under reasonable consideration, one would have to give some months to regain ground at some level. It's not just that we
Because
end lockdown yesterday.
you had a lot of businesses that closed because of COVID, never reopened.
Yeah.
COVID was a fatal blow to many businesses. That it just never reopened. They just closed down, and
Yeah, a lot of businesses just couldn't withstand the bounce.
Yeah, couldn't take it. Yeah.
Including some of, I'm sure, Mr. Chin's tenants. You understand?
Yeah.
Not everybody reopened inside the day. A lot of people just couldn't. The businesses couldn't sustain it. They didn't have to continue.
Theater was one. Theater, all theaters stopped. I mean, because you couldn't have public events. So I mean, we felt it firsthand in terms of your industry, even though you don't say it's an industry, Paul.
One of the interesting things, one of the interesting things Mr. Alexander said is that he had that phone without prejudice conversation with Mr. Chin, which I guess is now is a private conversation where he said Mr. Chin told him we can pay the rent, but our attorneys told us not to.
Yeah, they have legal advice.
You have legal, and you're going to follow your legal advisors.